Brown v. Mississippi, Supreme Court, 1936. Chief Justice Hughes delivered the opinion of the court. The question in this case is whether convictions, which rest solely upon confessions shown to have been extorted by officers of the state by brutality and violence, are consistent with the due process law required by the 14th Amendment of the Constitution of the United States. Petitioners were indicted for the murder of one Raymond Stewart, whose death occurred on March 30th, 1934. They were indicted on April 4th, 1934, and were then arraigned and pleaded not guilty. Counsel were appointed by the court to defend them. Trial was begun the next morning and was concluded on the following day, when they were found guilty and sentenced to death. Aside from the confessions, there was no evidence sufficient to warrant the submission of the case to the jury. After a preliminary inquiry, testimony as to the confessions was received over the objection of defendant's counsel. Defendants then testified that the confessions were false and had been procured by physical torture. There is no dispute as to the facts upon this point, and as they are clearly and adequately stated in the dissenting opinion of Judge Griffith, showing both the extreme brutality of the measures to extort the confessions and of the participation of the state authorities. We quote this part of his opinion in full as follows. The crime with which these defendants, all ignorant Negroes, are charged was discovered about 1:00 p.m. on Friday, March 30th, 1934. On that night, one Dial, a deputy sheriff, accompanied by others, came to the home of Ellington, one of the defendants, and requested him to accompany them to the house of the deceased, and there a number of white men were gathered who began to accuse the defendant of the crime. Upon his denial, they seized him, and with the participation of the deputy, they hanged him by a rope to the limb of a tree, and, having let him down, they hung him again, and when he was let down the second time, and he still protested his innocence, he was tied to a tree and whipped, and, still declining to accede to the demands that he confess, he was finally released, and he returned with some difficulty to his home, suffering intense pain and agony. The record of the testimony shows that the signs of the rope on his neck were plainly visible during the so-called trial. A day or two thereafter, the said deputy, accompanied by another, returned to the home of the said defendant and arrested him, and departed with the prisoner toward the jail in an adjoining county, but went by a route which led into the state of Alabama. And while on the way, in that state, the deputy stopped and again severely whipped the defendant, declaring that he would continue the whipping until he confessed, and the defendant then agreed to confess to such a statement as the deputy would dictate, and he did so, after which he was delivered to jail. The other two defendants, Ed Brown and Henry Shields, were also arrested and taken to the same jail. On Sunday night, April 1st, 1934, the same deputy, accompanied by a number of white men, one of whom was also an officer, and by the jailer, came to the jail, and the two last named defendants were made to strip, and they were laid over chairs, and their backs were cut to pieces with a leather strap with buckles on it, and they were likewise made by the said deputy definitely to understand that the whipping would be continued unless and until they confessed, and not only confessed, but confessed in every matter of detail as demanded by those present. And in this manner, the defendants confessed the crime, and, as the whippings progressed and were repeated, they changed or adjusted their confession in all particulars of detail so as to conform to the demands of their torturers. When the confessions had been obtained in the exact form and contents as desired by the mob, they left with the parting admonition and warning that, if the defendants changed their story at any time in any respect from the last stated, the perpetrators of the outrage would administer the same or equally effective treatment. The state is free to regulate the procedure of its courts in accordance with its own conceptions of policy, unless in doing so it offends some principle of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental. But the freedom of the state in establishing its policy is the freedom of constitutional government and is limited by the requirement of due process of law. Because a state may dispense with the jury trial, it does not follow that it may substitute trial by ordeal. The rack and torture chamber may not be substituted for the witness stand. The state may not permit an accused to be hurried to conviction under mob domination, where the whole proceeding is but a mask, without supplying corrective process. The state may not deny to the accused the aid of counsel, nor may a state, through the action of its officers, contrive a conviction through the pretense of a trial which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of the court and jury by the presentation of testimony known to be perjured. In the trial equally is a mere pretense where the state's authorities have contrived a conviction resting solely upon confessions obtained by violence. The Due Process Clause, that state action, whether through one agency or another, shall be consistent with the fundamental principles of liberty and justice which lie at the base of all our civil and political institutions. It would be difficult to conceive of methods more revolting to the sense of justice than those taken to procure the confessions of these petitioners, and the use of the confessions thus obtained as a basis for conviction and sentencing was a clear denial of due process.